We've got 9 people online, yeah? Hello? Yeah, hello everyone. Welcome to panel 8 of SIEL Global Conference. And my name is Suresh Nanwani, and I am the moderator for this panel. I wish to welcome each and every one of you to this panel on SOEs. And I am Professor in Practice at Durham University and Honorary Associate Professor at Australian National University. My panel members are 4, and they have rich and varied backgrounds and experiences. They are Wei Yin from Southwest University of Political Science and Law, China, Freya Baetens from Oslo and Leiden universities, Mark McLaughlin from Singapore Management University, and Wang from University of New South Wales. I'm just giving a brief introduction because we probably know each other and we can connect with each other. So to save more time for the discussion, I put it to that. And now they all come from different parts of the world. So we are all coming from Australia, Philippines, China, Netherlands, UK. We all share one thing in common at this session: state-owned enterprises. And our wish is to stimulate discussion and debate, and we appreciate inputs from all of you in the public chat, which will be used after the speakers present. Each speaker will have max 9 minutes, and after each speaker, I will ask a question and then open it to the audience. I will check on the public chat, and I can see we've got Pasha as well, so that's good. He's been giving us support. And now roll in your questions. So I want to just start a little bit. SIEL. SIEL, that is society. IEL is international economic law. I want to segregate the two for the time being. We are a society now, society of folks. In this time, we are a society, and we have this interest called IEL. That's what pivots us to bring and share with everyone here our discussion. And on that note, I want to start off the panel, and the first speaker is Wei Yin. Her topic is on rethinking the norms of state-owned entities in international economic law, subjective or objective tests. Wei Yin, the floor is yours.
Okay, thank you very much, Suresh. I try to have my own timekeeper. And good morning, good afternoon, and also good evening, everyone. It's my pleasure to speak at this SOE panel. Thank you very much for our moderator and my dear panelists, and also of this conference. The topic that I'm going to share today is rethinking the norms of SOE. I'm thinking about why SOE has attracted attention by regulator and how they are treated. And are these existing rules framed in an appropriate form? Actually, the government intervention and state-owned enterprises are not unfamiliar to most of us, and also to the history. But why the state-business relation and the role of SOE becoming the focus of emerging negotiations and international rulemaking? This might attribute to some of the following reasons. One is that the performance of emerging countries in responding economic and financial crisis, and also afterwards, and their contribution to the world economies. One feature of these countries is the role that SOE played in their market. And also, this can be attributed to the expansion of SOE activities worldwide, especially flow from domestic market of developing country to developed countries. And also with the advancement of Belt and Road initiatives that affects the state, where multilateral corporations have already touched, and the conflicting and divergent views on economic development model and also on WTO reforms also lead to members to take measures out of the WTO regime. Actually, there may also some geopolitical issues or reasons, but not the main discussion that I want to address today. But it seems that these are more state level rather than company level issues. So what causes have SOE caused so that the new policies and measures are marked or labeled as SOE specific disciplines or rules? Actually, in existing literature and some working report provided by international organizations, concepts associated with SOE are as follows. The unlevel playing field, market distortion. These are economic concepts, in particular relation to competition issues. And they are also concepts in relation to driven by political rather than commercial purpose. And also the foreign ownership of critical assets. These are more political concepts, especially in relation to national security problems. And there are also concerns in relation to their internal corporate governance, for example, the lack of transparency and also the organizational structure. And these common concepts are highly linked with their characteristics, that is the state ownership or state control or even state financing. And due to the close tie with the government based on the ownership, and the hybrid objectives, the social and also purely commercial objectives. This can be explained as how the state adjusts the relationship with the business, and how the state regulates the market, and how it pursues its interest and development. Actually, the adverse impacts of SOE also mentioned in many papers and reports, but empirical study to support this argument are weak or rare. And this is also due to some of the fixed mindset caused by some economic systems. And on the other hand, the SOE do provide benefits to countries which are recognized by certain studies and also OECD working papers. And from my own perspective, there is some contradiction in existing views on SOE. That is, first, the rigid division of public and private, whether it can reflect the dynamic market and also the market participants. And second, problems that associated or assumed with SOE can also be actually found in those private companies' practice. And also, as I mentioned, the hybrid objectives of SOE actually is also one of the things that are advocated by certain governments concerning the corporate social responsibilities of all companies, especially what we call private companies here. And then the third thing that I want to highlight is that the regulation is supposed to protect the vulnerability of the industry and the public interest of the host country, rather than the target of the background or the ownership of the enterprises. And last but not the least, international law mainly defines the rights and obligations of the state. And the regulation on SOE by international rules is carried out indirectly by defending the rights and obligations of the states. And now the so-called international rules, SOE, the SOE specific rules are supposed to be rather than the SOE themselves. We should not always attach activities of SOE to the state or treat all the SOE as a part of state organ. The question herein is that when the behavior or conduct of SOE can be attributed to the state, thus leading to the state as responsibility under respective international law or regarding violation of international rule. And this may be addressed by Professor Freya Baetens later. And then it can be seen from international law, trade law, and also investment law that obligations are imposed on states, but not the SOE, while the rights and benefits are provided for companies. For example, the investment treaties. And despite conflicting decisions or cases are linked to how to differentiate the commercial activities of SOE from their exciting function. That is a more conduct-based test rather than the ownership-based test. And recently, some mega-regional agreements are regarded as new models for SOE rules due to their incorporation of SOE relevant rules to address the level playing field and the subsidy issues. This treaty is particularly CPTPP, USMCA, and the by Dr. Wang. And these treaties include provision with regard to the definition of SOE, substantial obligations concerning no commercial assistance, commercial consideration, but they also have exceptions or exemptions. These treaties are sometimes regarded as WTO plus treaty by some scholars in terms of their scope and to address trade and also investment issues. And the contribution and the limitation of these treaties have been analyzed by some trade law scholars. So I won't spend explain in my presentation. But these treaties do lead to discussion concerning whether these SOE specific rules can address concerns raised by some contracting parties or WTO members. While my first is put on by exploring what kinds of benchmark or test can the SOE conduct be judged or exempt and can be attributed to the state's obligation or commitment under international law. And the view that holds by my research is that a conduct-based test rather than ownership-based test is more appropriate to avoid regulatory bias and also to maintain a regulatory neutrality. And consensus should be achieved, and the SOE stakeholders should also be given the right to express their views or involved in certain rulemaking. And due to the time limits, this concludes my presentation. Thank you very much.
Thank you very much, Wei. I think it was very good that we were brought back. It's like a 101 for me now, and I really enjoyed it because it's like what it's all about, the SOEs, and you mentioned the GATT and the accumulation of rules, etc., OECD guidelines, subjective, objective tests. And now I think you went up as quite high to the state responsibility as well. And this is a very good point because there's a flow, and that's what I like about the way the presentation is done here. The presentation is from that 101, as it were. We now move up to the level of attribution of conduct of state-owned enterprises to states in terms of new rules, new prominence. And for that, let's listen to Freya.
Thank you very much, Suresh. Can you hear me?
Yes, we hear you very well.
Great. Quick check.
Good.
So, attribution of conduct of SOEs to states. Why do I talk about new prominence? Because if you look in recent years, the prominence of SOEs on the international has enormously increased. For example, if you look at the Fortune Global 500, 1 out of 4 companies are SOEs, including in the highest 6 ranking companies. There are 4 SOEs. They own trillions of assets. They employ millions of people, and they're often massively subsidized, and that is taxpayers' money going into companies. So SOEs are increasingly prominent players in worldwide markets, but that does not seem to have been a situation that was foreseen by international lawmakers. And then, of course, I think when it comes to attribution, in the first place of the International Law Commission. And why is that important? Why should we even think about revisiting the rules on attribution? Because states may, in some cases, be using SOEs to circumvent, knowingly or unknowingly, circumvent their own obligations under international law. SOEs differ from private companies. They differ in terms of immunities, in terms of their funding, in terms of their responsibilities. But it's very unclear whether or even which international rules apply to them, since they are private companies. And one entity that is very worried about this is the European Commission, who already in its paper on WTO reform in 2018 indicated that SOEs could have a market distorting behavior. It therefore is important that it should be clarified whether they perform government functions, whether they further government policies, and to what extent states actually have meaningful control about over this company. Now, I don't need to use my time here to explain what international rules on state responsibility are. I'll leave it just to say that my starting point is that the International Law Commission developed a set of rules finished in 2001, looking particularly at attribution in the context of wrongful acts of states, which have in the meantime been expanded to also apply by analogy in other contexts where there's no wrongful conduct. But for example, in my presentation, I want to say something about standing as well, standing before international tribunals. And if we look at these rules, there's roughly speaking 3 ways in which acts can be attributed to the state. One is if a certain entity is an organ of the state, SOEs are not mentioned in that context at all. Secondly, if they conduct elements, or if they exercise elements of governmental authority. And in that context, there has been some discussion about state-owned airlines that had delegated powers in relation to immigration or quarantine, very important in these days, or about foundations holding property for charitable purposes, and then including the power to identify property for seizure. That's something you find in the case law of the Iran-US Claims Tribunal. The only rule where SOEs were discussed was when we talk about conduct directed or controlled by states, and they recognizes in general, acknowledges the separateness of corporate entities, and except in those cases where it can be proven that the corporate veil is a vehicle for fraud or evasion of rules. So that is from Barcelona Traction. Insofar as SOEs are considered to be separate, however, prima facie, their conduct in carrying out activities is not attributable. And it's only when there's proof that the state is using its ownership interests or control over a company, especially in order to achieve a particular result, that you can attribute the conduct to the state. But so as far as the theoretical rules and the development of rules is concerned, there has been very little thought about SOEs. And that has changed in practice. I'd like to point you at investor-state arbitration, WTO law, and also some adjudication in the human rights field to show you how differently SOEs have been treated, and then we can later discuss whether that is actually a desirable situation or not. If we think about investor-state arbitration, first of all, in the context of standing, for example, the ICSID Convention, but many other rules as well, say that the claim has to be a private party, a national of another contracting state. If that is not the case, that entity cannot bring a claim. And then you see investor-state tribunals talking about whether a state is a sole or a majority shareholder. That doesn't seem to make a lot of difference. It's still considered a private entity. And then there's a whole range of cases where they look at performance with the party. And there, it can vary quite a bit. we're talking about SOEs involved in airport management, in land management, even in universities, and how that is looked at, both in the context of establishing standing and establishing responsibility in case of a potential wrongful act, is very, very different. Exception in investment law, and that is if you have a lex specialis, and one of those lex specialis that actually addresses the issue is the ECT, which very clearly allows for SOEs to bring claims, and also quite clearly says that states have to ensure that SOEs are conformity with the treaty. And that is very helpful to the tribunal because it takes away the pressure from proving that a particular conduct is attributable to holding the state responsible for not preventing the conduct of the SOE, regardless whether that conduct is attributable or not. And moving to WTO dispute settlement, of course, there's no issues about standing of SOEs there. But also when it comes to substantive matters, the WTO agreement is largely silent on matters of attribution and matters of conduct of SOEs, except maybe some single Article 17(1)(a) of the GATT, which refers to contracting parties have to undertake if they establish or maintain a state enterprise wherever located, or grants to such enterprise exclusive or special privileges, such enterprise shall act in a manner consistent with the general principles of non-discriminatory treatment. That's just a very singular reference. Another one can be found in the agreement on the SCM agreement on subsidies and countervailing measures, which talks about financial contributions by a government of a public body, or where the government makes payment to a funding mechanism or entrusts or directs a private body to carry out one or more of the type of functions which would normally be vested in the government. And there again, you see that panels and the appellate body have had differences of opinion, where some said, well, the same entity can character, so either an SOE is part of the government and subject to the rules, or it's not. But the appellate body has held, no, you have to look at the performance of each specific function, and even within that function, potentially each specific act. Then they have tried to identify some, also, for example, the power to appoint board members, which is something you see pops up in investment law as well. Again, whether that is considered making the acts attributable or not, very much depends on from case to case. Whether it's a public or a private body, whether an SOE is a public or a private body, is again, and whether what the meaning exactly is of concepts such as entrust, directing, again differs in the case law. But instead of having this conduct necessarily attributing this conduct, you see the same solution in WTO law, where the obligations or the acts of these SOEs may not be attributable, but the state is held accountable for not preventing them. And then finally, in human rights adjudication, originally the focus was very much on standing issues, where both the European Court of Human Rights and the Inter-American Court of Human Rights have allowed applications quite clearly. They have taken a very broad approach. Issues again maintained when it comes to establishing state responsibility, where they have developed a much longer list even of looking at the company's legal status under domestic law, its operation, its institutional independence, its operational independence. And for example, in a case on debt recovery, the Grand Chamber of the European Court of Human Rights held that if it's the state that is responsible for the company's financial difficulties, that can be seen as potentially acting in abuse or abusing the corporate form. And again, same as in investment and WTO law, the courts have moved towards saying, well, regardless of attribution, we circumvent the issue. The state should have prevented certain acts of its own SOEs, so thereby indirectly bypassing the corporate veil. Now, I have a very short conclusion. That is, first, I would like to posit that SOEs push the interpretative boundaries of international law rules on attribution of conduct across a variety of fields and on a variety of issues. wrongful acts and others. Cases involving SOEs are on the rise, perhaps because there's more of them around, perhaps because they have wider access to dispute settlement mechanisms, but the rules were clearly not developed with SOEs in mind, leaving it up to the courts and tribunals to fill the gaps, and we may discuss whether this is desirable. The jurisprudence as a result in all the fields is inconsistent, but there's some treaties and treaties currently under negotiation are a bit more tailored towards catering for specific situations. So if you look at CETA or CPTPP, they do have a chapter on SOEs, but it does not really address these issues at length. So my conclusion is, I think a general revisit of attribution rules would seem desirable, but again, which form that should take is a discussion. Thank you very much.
Thank you, Freya. It was really wonderful to now land onto the international level and see how, you mentioned about the lex specialis, and then you talked of SOEs pushing the boundaries. And I think that's really fascinating, because where do the boundaries go and how far do they get stretched? And when you talk of human rights adjudication, it seems like there's so many areas now that they would not even have been thought of before. So it's getting to be a bit scary, but this is what it's all about when you deal into boundaries that are not clear, and you've got case law, more reason for clarity needed, and the boundaries to be demarcated. You have certainly made an impact on the number of SOEs that there are, and now with the third speaker, McLaughlin, we now move into an area which is into regulating state-owned enterprises in Chinese investment treaties. Over to you, Mark.
Well, thank you very much, and good morning, good afternoon, and good evening, wherever you're joining us from all over the world. I think Wang and Freya have given a really good foundation to what my presentation is going to be in terms of the growth of the prominence of state-owned enterprises and quite how important they're becoming in the global economy more generally and in international economic law. Now, I think I should kind of delineate the scope of my presentation here. So state-owned enterprises can operate within their home states, and it can raise some trade issues. But the thing I'm discussing is Chinese state-owned enterprises when they act as foreign investors, when they act overseas. And so there are four main questions that I'm going to answer through the course of this presentation. The first is, why do Chinese state-owned enterprises present a unique regulatory challenge? What are these challenges? How have host states responded? And how do these responses with investment treaty obligations? So just to take the first one, why do Chinese SOEs present such a unique regulatory challenge? And it stems from the distinction between public and private enterprise in the Chinese context. So in Western societies, it's not a absolutely hard line between public and private, but it is certainly more porous in the Chinese context. So there is an existence of a supervisory body for state in China, and it is the function of the state to participate in major decision-making for some major SOEs and contribute to the selection of management. And so even with privately owned enterprises, it's even been suggested that analysis of state control and Chinese state control must move beyond ownership. This is something that Wei talked about, for example. You need to look beyond ownership and into conduct and into action. And so you can look at things like the political connections of the management, the extent of financial support from government, chambers of commerce, coordinating activity, regulators conducting interviews to compel or encourage compliance with government policies, and kind of participation in restructuring. But on the other hand, there are significant principal agency gaps in the governance of Chinese enterprises that indicate a high degree of operational autonomy in some instances. And so the level of government involvement in decision-making varies considerably. So even for legally specified major decisions, the board of directors is incentivized to pursue a firm-specific strategy, not a national strategy. And the scale and intricacy of Chinese investment overseas make that kind of micromanagement at that level, and a daily micromanagement level, highly impractical. And directors' remuneration is based upon the commercial value they bring to SOEs, not on the basis of pursuing state control. And for these reasons, the examination of the relationship between a Chinese company and the Chinese state requires a nuanced case-by-case analysis, and that generalizations should generally be avoided. So the main concerns raised in relation to Chinese state-owned enterprises, there are three. The first relates to national security. Areas where this were specific would very obviously fit a definition of national security. For example, if a Chinese state-owned enterprise attempted to acquire any defense-related technologies for a manufacturer of arms and so on. But there are also things that are much more grey areas. So things like critical infrastructure, the participation of Chinese state-owned enterprises, particularly in Asia and through the Belt and Road Initiative, and building railways and ports. These would be regarded as critical infrastructure, for example, in the United States, and would be caught by provisions on the Committee for Foreign Investment in the United States as certainly reviewable, but in other countries as designated not as critical infrastructure. So one of the problems with national security is it's really a difficult and ambiguous definition. So the second issue with Chinese state-owned enterprise is competitive neutrality, the idea that there are somehow anti-competitive practices, that they may be subsidized for their home states or acting in concert. So the EU's merger control regulations, there are a few cases in which Chinese enterprises are analysed as to whether they have, for example, the independent power of decision, whether they act alone, or whether, for example, they act as a group. And that would have significant implications as to whether any potential acquisition by a Chinese state-owned enterprise would be approved. And so alongside national security and competitive neutrality, the third state-owned enterprises as to their corporate governance, so that they pursue, for example, non-commercial policy objectives, that there's a lack of transparency, that there are lower standards of responsible business conduct, and the investment screening mechanisms on Australia's Foreign Investment Review Board, there are specific provisions regulating things like corporate governance. So I think at this point, it's necessary to do something that Wang mentioned as well, is to distinguish between concerns about state-owned enterprises versus the actual evidence that they actually participate in this conduct. So there are very few empirical studies as to whether the Chinese state-owned enterprises do actually operate on a commercial basis. And in fact, in the OECD, it suggested that state-owned enterprises don't make materially different decisions in terms of acquisition than their private equivalents. And so analysis of Chinese state-owned enterprises in terms of their commerciality, for example, should be on a kind of nuanced state-by-state and case-by-case basis. So host state responses to these concerns, the most important one is the investment screening mechanisms of national states. So the United States, Australia, the European Union, especially, Freya mentioned that, the European Commission, how they're responding to Chinese state-owned enterprises is changing, particularly in the United States. The standards of investment screening, for example, when a Chinese state-owned enterprise tries to acquire a company in the United States, is becoming stricter and stricter. There are particular standards that apply. Now, when you look at the provisions, they say that they are geared towards national security. National security is almost always a standard that is applied, but it can be broader, and particularly in the case of China and the concern about China's Belt and Road Initiative and the Made in 2025 approach to acquisitions of Chinese state-owned enterprises, they have a particular concern that, in my opinion, goes beyond national security. It's about geopolitics, and so those are being introduced into the areas of investment law. But when states are regulating state-owned enterprise, they don't operate in a legal vacuum. They operate specifically in the context of international investment law. Now, I'm not going to go too much into the detail of whether state-owned enterprises are considered protected under investment treaties, because quite a lot of work has been done on that. But in general, international investment treaties have an ownership neutral approach to protection. So they use words like national or companies. And in a couple of cases related to ICSID, they have been regarded to be protected under investment treaties. So for the purposes of this, I'm going to assume that Chinese state-owned enterprises are indeed protected investors. And so when you look at the interaction with international investment treaties, there are generally four conclusions. And the first is that the Chinese BIT model, and in fact the broader international investment regime, is evolving to accommodate state-owned enterprises within their provisions. And it has become apparent in a few quite obvious ways. The first is the explicit inclusion of state enterprises within definitions of investment and investor. In other words, there's a conscious decision to remove the ambiguity as to whether state-owned enterprises are in fact covered, and they are now frequently included within the definition of investment. So that's the first way. The second way is in the broader investment regime and accommodating state-owned enterprises within, for example, the purview of the VIII Convention, which, as Freya mentioned, has in its definition and its scope says it has to be a private entity. But despite that, a couple of cases have ruled that state-owned enterprises do, in fact, come within the purview of the VIII Convention. So, in general, the Chinese BITA model and the broader investment regime is accommodating state-owned enterprises. My second conclusion is that states retain considerable discretion to regulate SOEs because of two particular characteristics of investment treaties. So the most important is the absence of pre-establishment national treatment. So in other words, that states can discriminate at the point of entry. So they can deny entry to Chinese state-owned enterprises on almost any basis at all, because international investment treaties do not regulate that area of investment treaties in general. There are a few minority cases in which pre-established national treatment is provided, but even in those cases, there are carve-outs for particular sectors, many of which are involved, many of which state-owned enterprises are involved in. And so despite this, despite the fact that states do have considerable discretion to regulate SOEs because of the absence of that non-discrimination in the pre-establishment phase, host states are not unconstrained about how they treat SOEs, and some standards do apply. So after SOEs have been admitted as investors, outright and blatant protectionism or nationality-based discrimination is still prohibited at the post-establishment phase, and state-owned enterprises remain entitled to due process. So states should still be wary, especially once they have admitted an investment, how they treat that investment. For example, after a change of government that takes a geopolitically different position on the rise of China than their previous administration, that would decisions taken on that basis would likely be caught by investment provisions. And I think my final conclusion is that the conduct of SOEs will be highly relevant to determining a breach of investment treaties. So fair and equitable treatment essentially acts as a catch-all good faith provision that would prevent SOEs acting and conducting business in a way that is contrary to the interests of host states, and investment protection would not be afforded in such instances. So reasonableness and the weighing of investor and host state conduct is a hallmark of the reasoning of many arbitral tribunals. And so if an arbitrator were considered, for example, the anti-competitive practices of an SOE as unconscionable conduct, then host states may be permitted to take measures that would be otherwise unfair. So in general, I think my main conclusion from this is that host states are taking particular regulatory responses to the concerns of state-owned enterprises that primarily take the form of investment screening. And in most cases, investment treaties do not regulate that form of investment screening. But in other cases where state-owned enterprises have been admitted, that there are rules that should be followed, and host states should be very conscious of that. But thank you very, very much for your time. And I'm looking forward to hear from Wang. Thank you.
Thank you, Mark. Thank you for walking us through the state-owned enterprises, SOEs, in the context of the Chinese, of the treaties that you mentioned in the Chinese investment treaties, and also offering us your conclusions or tentative conclusions there that you can build up on. And I'm sure this is really interesting that we want to explore later on. I apologize. I sent it to the public chat for your 1 minute. My mistake, but I'm only a mortal. So there you are, Mark. It wasn't meant for you. It's for everyone. My apologies for that, and to the public, of course. That's lovely. Hello. Okay, it's always good to have a surprise appearance. Okay, very good, very lovely. Now, I think with that, we are armed with, now in the Chinese investment treaties, and now we're on this level now that I think we're going into something that I don't want to spill the beans. It's for Wang to tell us something about a model. And I know she's got a model because she's talking of something very clear. And in that, her topic itself is SOE disciplines in the EU-China Comprehensive Agreement on Investment. So I've given you the clue, but that's in a topic. Over to you, Wang, please.
Thank you very much, Suresh. Can you hear me well?
Yes, loud and clear. Good.
Hello, everyone. I'm very delighted to see you all online today, and it's my great honor to be part of this very topical but also very stimulating panel with very distinguished speakers looking at one of the most significant yet challenging issues of regulating state-owned enterprises. So my draft paper focuses on the state-owned enterprise disciplines provided in the recent comprehensive agreement on investment between the European Union and China. The KAI is regarded as a landmark achievement of the two major economies in the development of international economic and trade rules, and a breakthrough of the KAI is the inclusion of SOE disciplines. I will address 2 points here. The first point is that the KAI, including substantive provisions on investment liberalization with SOE disciplines and regulatory principles, signals a significant shift in China's attitude to regulation of SOEs. Previously, China were reluctant the SOE discipline specific rules in existing Chinese free trade agreements that directly regulate the behaviors and conduct of SOEs. The negotiation on BIT with the United States reflects the US concerns over Chinese SOEs, but there's no result. Even in the US-China phase 1 deal, SOE disciplines are subject to future negotiations. However, there's a change in the KAI. China for the first time commits to discipline SOEs and fair competition in an international investment agreement. It's not very surprising to see in the KAI the provisions on SOEs. For the EU, the SOE disciplines reflect its long-standing concerns over the market distortion effect, competitive behaviors of SOEs. More importantly, there's growing concerns over China due to its impact on global activities and also the unique by state capitalism. In addition, the EU considers there's favorable treatment to SOEs and restrictions to EU investors in China, which has contributed to the asymmetry in respect of investment protection and regulation. So in this context, the KAI would be a useful international legal instrument to discipline Chinese SOEs to ensure a level playing field for and investments. For China, SOE is also a critical issue in negotiating international trade and investment agreements with its major trading partners, including the US and the EU. Recently, as Mark has also highlighted, the EU appears to take a more defensive approach to regulating foreign investment at the EU level in response to growing concerns over national security and fair competition in relation to Chinese SOEs. So a major concern of China is to address concerns over the tightening FDI controls in some EU member states and also at the EU level, and to ensure investment protection to Chinese investors in the EU. Unfortunately, the investment protection is absent in the agreement in principle, but KAI explicitly states that the BIT between China and EU member states will remain in place. On the other hand, China has gradually lifted some restrictions on foreign investment through, for example, the national list for market access, and has also committed to advance investment protection and fair competition in its domestic laws. And I think the KAI reflects such development and signals China's openness to international SOE disciplines. This is remarkable because China's commitment to regulating SOEs in KAI is an international obligation and subject to international disputes resolution mechanism, which would have far-reaching implications for international investment governance and also policy making. The second point I'd like to share is that I think the KAI provides incremental and balanced approach to regulating the behaviors of SOEs in international trade and investment agreement, which is a joint policy response of the world's two largest economies, the EU and China, to the rising concerns over SOEs, and will likely have far-reaching implications for future national and international investment policymaking, not only to SOE disciplines, but also other provisions on investment liberalization, investment protection, and dispute settlement. To be clear, the CAI is not the first international agreement regulating SOEs. We've seen the WTO rules and some US FTAs provide provisions on SOEs, and a remarkable recent development is perhaps the TPP or CPTPP, which contains detailed rules on SOEs and reflects the US approach to discipline SOEs. By contrast, agreement between the EU and China to, as I quote, deliver on detailed obligations for the behavior of SOEs, of a breakthrough in international investment policymaking and SOE disciplines. On the one hand, it develops provisions of the EU's recent free trade agreements with Japan and Vietnam on SOE rules. On the other hand, as I said earlier, it signals China's changing position on SOE disciplines in international investment agreements. Of course, there were some problems, and the political or strategic factors play a role in the inclusion of SOE rules and obligations. And but still, the SOE rules in line with the EU and China's pre-existing commitments in other agreements, and reflects EU's recent investment treaty practice and China's domestic liberalization and reforms. In relation to the specific provisions on SOEs in CAI, there were some innovations in drafting. Given the time limit, I will just highlight several features here. First, the CAI adopted an expansive definition of SOEs. It does not refer to the term state-owned enterprises or SOEs directly. Instead, it uses the term covered entities, which actually goes beyond the majority ownership or traditional control test contained in other free trade agreements, and thereby include a much broader defined category of enterprises directly or indirectly owned or controlled by the government. In addition, state-designated monopolies or entities vested with special rights or privileges are also subject to international obligations. Such a broad definition of covered entities is in line with the due consideration of ownership and control. And it also includes interesting innovations to address anti-competitive concerns over other public or private entities designed or authorized by government with privilege or monopolistic positions in relevant market. Secondly, the CAI requires covered entities to act in accordance with commercial considerations and provide non-discriminatory treatment in their purchases or services. In terms of the non-discrimination obligation, the CAI explicitly requires that the comparators that are used to assess the treatment accorded by covered entities in respect of purchase of goods or services are like goods or like services supplied by the home parties, investors, and entities, or subject to in-like situations in respect to sales of goods or services. In relation to the obligation of acting in accordance with commercial obligations, this is subject to commercial activities of covered entities and does not apply to situation of trade in goods and to supply services other than through establishment of an enterprise and operation of a covered investment. Compared to the commercial considerations defined in the CPTPP, the CAI does not limit the other factors taking into account in commercial decisions to those of privately owned enterprises in the relevant business or industry. Instead, the CAI focuses on factors that would normally be taken into account in commercial decisions of enterprises, regardless of publicly or privately owned or controlled, that are profit-based and disciplined by market forces. Despite the broad scope of covered entities and detailed rules on substantive obligations, SOE disciplines in CHI are subject to certain exceptions. While some may argue that the exceptions are extensive and thereby undermine the obligations for SOEs, such exceptions are actually legitimate and necessary for both the EU and China to leave sufficient policy space to exercise both public functions of SOEs. This, as each party has considerable number of SOEs, and there are different and specific sensitivity or strategic sectors for them to protect or take into account in negotiating international agreements and to balance with international SOE disciplines. Nonetheless, I agree with other too extensive exceptions or carve-outs may complicate the scope and application of SOE disciplines. The CHI does not only provide obligations for covered entities on non-discriminatory treatment and transparency for addressing the anti-competitive concerns, but also explicitly extends such obligations to regulatory authorities. Accordingly, regulatory authorities of each party shall also act impartially in like circumstances to all enterprises in non-discriminatory measures. Be helpful to improve the level of playing field between the public and private companies. So to sum up, the CHI provides an incremental and balanced approach to regulating SOEs with some innovation. It develops the SOE rules on the basis of EU's recent practice, while China for the first time commits to international SOE disciplines in a bilateral investment treaty. Despite some critics of the agreement in principle, I'd like to highlight that the CHI at least provide a useful different approach, setting an incremental and balanced model or template on SOE disciplines in international arena to address concerns and challenges over SOEs, which should not be overlooked, and worth further studies on its implications for future international governance and international policy making.
Thank you. Thank you very much. I see we've got some questions coming in from the public, which is wonderful, and it's okay. I've got them in stock, and I've actually rolled them in. Thank you for that, and I will attend to those questions, and we certainly welcome and appreciate the public chat questions. Let me just, please, if that's okay with the public, I just want to ask a question each from each speaker, and then depending on the kind of questions asked, we will farm them out as those that have been highlighted to specific persons or to general, on more general basis. So let me start with the questions that I have here, because as a panel, we've worked together, and I think this team spirit is so important. We ourselves have many unanswered questions, and I'll be very honest with you. If we had all the answers, I think there wouldn't be any questions asked amongst us and by the public as well. But questions will always be there, and that's what it's all about, to learn and to find out. So the first question I have for Wei is, in your view, Wei, how do you think we should understand the legal status of SOEs? And the subset is the current rule on the legal status of SOEs heading in the right direction? So let me phrase it again, yeah? In your view, how do you think we should understand the legal status of SOEs? And then, do you think the legal status of SOEs is heading in the right direction? That's it.
Okay, thank you very much, Suresh.
Thank you.
I will answer your question in short sentences. Actually, for the first one, my research preferred the adoption of a more, as I mentioned before, a conduct-based, or we can say the activity-based approach to understand the legal status of SOE, to differentiate those SOE that exercising government function from those conducting commercial activities. That is the main view that held by my research. And also recognize those companies pursue of objectives that rather than only the profit maximization. Actually, there is also a trend that in the discussion of profit maximization in corporate law, and also to encourage and whether to encourage all the companies to incorporate social responsibility or to undertake socially responsible investing, and also to consider ESG elements. You can see that even in what we call purely private-owned enterprises, they also have to consider the profits and also some social responsible elements. So that is the first thing that I want to mention. And the second question, actually, I have a question for myself, especially for my research. So what is the right direction? So who can define the right direction to regulate SOE or to regulate the state regulation or management of SOE? That is the question. So actually, we do not now have a benchmark for what is the right direction. So they may have some views in some papers and also in my research. Actually, I think this or all these rules heading in a right direction. Actually, they also, the expression or the language in certain provisions or rules actually misleading the understanding of the subject of these rules. And also in international economic law, rules are actually the main purpose is to address economic issues. And at international level, obligations should be imposed on states with its concept bilaterally or multilaterally. And for SOE, like other companies and investors, are supposed to comply with the domestic law of host countries. Actually, this requirement can be found in many bilateral and international investment treaties. And for SOE specific rules, I think this could be formed like what have been done for multinational corporations. Actually, decades ago, the multinational corporations also raised a lot of issues or problems that call for rules or regulation on their overseas conduct. So here has a guidelines for their conduct. Now, whether we can also think there might be guidelines for the SOE conduct, but not only provided by OECD itself, but may also to get more stakeholders involved in these guidelines rulemakings. So it ends my answers here.
Thank you very much, Wei. From what I gather, it seems like it's really the jury is still out in the sense that there's so many perspectives to look at, with the examples you've cited. And it reminds me very much of Hamlet, to be or not to be, what is the question? And I'm sorry if it was tough, but, I'm not a teacher, but certainly you have exposed to us, the manifold facets, and I appreciate that. Thank you. The next is Freya, and it's going to be, what the question I have here is, do you think we should aim for a uniform approach to establishing attribution of SOE's conduct across international trade and investment law? both within the context of wrongful acts, and beyond? And what are the pros and cons of such an approach? So it's a big question. Let me sort of break it down a bit. Do you think we should aim for a uniform approach to establish attribution of SOE conduct across international trade and investment law, both in the context of wrongful acts and beyond? And then what are the pros and cons?
Okay, thank you, Suresh. That's a very big question. Actually, I could give another 10-minute or even longer speech on just that question.
Yeah, I know. You've got only 3 minutes, but answer the best you can. I mean,
I'll do the best I can.
Yeah,
well, I have to admit to being a bit of a dinosaur in the sense that I'm a general public international lawyer, and I realize this is the Society of International Economic Law, and my topic has an important economic effect to it. But essentially, I would advocate against better knowing and against political feasibility, probably, that I do think there should be a uniform approach to attributing acts of SOEs to states, not just in trade and investment, but in all areas of international law. I think there are issues that appear, for example, in investment arbitration, and the same issues pop up before the European Human Rights Courts. We've had disputes that have been fought in Geneva before WTO panels that also popped up before investment arbitration. And I think the idea that the same conduct of the same party would be attributable under one set of rules and not attributable under the other is a very undesirable situation. Where I do think we can make and undesirable because of predictability of rules, because of stability of the system, and just because the same act should be legal or illegal under international law, no matter who you ask. Where I do think we can make a difference potentially is attribution for wrongful conduct, or attribution in a different context, such as standing. I think there potentially, but actually the convergence there is already bigger, so maybe there's not even a need. But I think you could make a difference. I think standing across the attribution for the purpose of standing should also be uniform, but the rules there could be different from attribution for the purpose of establishing a wrongful act of a state. That's the best I could do in limited time.
Thank you. It was an absolutely loaded question, but of course it is something that is so important. And I think one thing that I get from this is you will keep everyone busy, including yourself, because this is what is so important, that we uniform approaches are good, and at the same time there are facets that one needs to consider. So thank you for sharing with us your view. My third question, which is to Mark, and to Mark, my question to you is this, which is, do you think investor-state arbitration is appropriate to settle disputes between host states and SOEs, or can you suggest alternatives? Let me repeat it, just for everyone to hear. Do you think investor-state arbitration is appropriate to settle disputes between host states and SOEs, or are there alternatives you can suggest?
I think that's complex. I think that disputes between state-owned enterprises and their host states raise particularly political issues that are akin, actually more like law. If you're looking at the kind of political filter on WTO law, because it's states suing states, there is by necessity a geopolitical or political element, a diplomatic element when you're suing a state. And so the involvement of state-owned enterprises in investor-state arbitration, considering quite how sensitive state-owned arbitration is anyway, the addition of the involvement of a state makes it very politically sensitive, I think, in that context. Although, so the alternative would be investor-state. One of the alternatives would be investor-state mediation, which is a kind of a slow but growing area. But then, in that situation, you would have the host state settling with a state-owned enterprise, reaching some sort of compromise. But given the politically sensitive nature of many investment disputes, particularly when there's a state-owned enterprise involved, I think that for investments related to the Belt and Road Initiative, for example, state-owned enterprises would be reluctant to initiate an arbitration because of the effect on the broader project. So if, for example, the investment by a Chinese state-owned enterprise along the Belt and Road became synonymous with kind of legal entanglements that you would, after accepting this investment, therefore end up in an international tribunal, would be bad for the project. And so for that reason, I think Chinese state-owned enterprises would probably not use investor-state arbitration. I think there are better, more subtle, more diplomatic methods to settle investment disputes rather than trying to enforce your rights at an international arbitral tribunal. Like there are broader consequences for that to public international law about the rule of law generally if there are state-owned enterprises that are playing essentially by a different set of rules. But because of the kind of political implications of the investment of Chinese state-owned enterprises, I think investor-state arbitration is probably not appropriate.
Thank you. So from what I get from you is that there are certain areas which are what I call, or you have called, the politically sensitive areas, and that adds a dimension that also reflects the reality of the situation. And thank you for sharing with us your view on that. My last question, and this is to Wang, is, it's wonderful that you've got this case study that you've given us of this EU-China agreement. And my question is on that EU-China Comprehensive Agreement on Investment. You were mentioning about it being a model in that sense for future disciplines. When you say model, I just like to tease you on that. Is that model like just a model, or the best model, or what can we gain out of it? Share with us. I know you said model, and I'm dying to know, what do I do with this model? Use it, or is that the best? Wang.
That's a great question. Thank you, Suresh. And I think that's also a very big and challenging question. Firstly, I think the CAI provides a different approach to regulating SOEs, not only because it's agreement between the two major economies, China and the EU, but also reflects in its specific provisions on SOEs. As I have mentioned earlier, the definition of covered innovative compared to the definitions provided in Prominence. And the definition is broader than the US approach in the TPP or CPTPP, and tests include government ownership and control, as well as the monopolistic power of the enterprises. In addition, the CAI provides substantive obligations for covered entities, including to act in accordance with commercial considerations and also provide non-discriminatory treatment in purchases or sales of goods or services. The EU regards this as a remarkable achievement, while some may argue that such obligations are subject to a specific footnote, which explicitly note that the obligation does not apply to situation of trading goods and to supply of services other than through establishment of an enterprises operate of covered investment. But it has features to focus on the behaviors of covered entities, namely the commercial activities of covered entities and the exercise of commercial authority, rather than focus on the identity of state-owned or state-controlled. And I think the CAI also includes specific transparency rules for covered entities, and the list of information by the transparency obligation is quite comprehensive, which could become a helpful way to address market distorting behaviors enterprises. While the transparency obligations under the comprehensive agreement investment between the EU and China are somewhat less ambitious compared to GDP, it reflects the EU and China's concerns over the transparency, and it's, as I said, a joint response, policy response to address SOE concerns, and might be easier for both China and the EU to implement in practice. Nonetheless, the KAI contains rules on transparency of subsidies, which may fill a gap in WTO rules on subsidies related to goods, and it's also imposing these transparency obligations on subsidies related. So, and it also provides a specific consultation procedures that will apply if one party consider any may have a negative effect on its investment interest. So there are some innovations in the drafting as well. Of course, challenges remain for the future. On the one hand, the current text is subject to further modification, and we know that the prospect of the agreement is uncertain due to the recent tension between. And on the other hand, some issues contained in traditional investment treaties, investment protections, and ISDS are unregulated. In addition, the efficacy of SOE disciplines, for example, the transparency obligation, implementations in practice, and all this remains to be seen in the future and need to be addressed in future negotiations. For future disciplines on SOEs, I think that KAI can be used as a different model or approach for international agreement negotiations on SOEs, and will likely have implications for domestic reforms. But honestly, I don't have an answer for what's the best model, but I think at least the SOE disciplines should focus more on the behaviors rather than its identity, and both entities and governments should act on a non-discriminatory basis. And I think that's the SOE rules in KAI reflect these concerns. Thank you.
Thank you very much, Lou. Thank you. We've got now, thank you very much for your responses. And certainly, I think if there's one thing I'm going to take away from that is when you put them in your articles or in your further research, I would definitely see lots of points being made there. I now go to the public chat. We've got about 10 questions kind of thing, and it all depends who they're asking questions here and there. So it could be to one person, it could be to one or two persons, it could be general. So let me as moderator be fair. So what I want to do is to farm them out, and I will just go through them. And I think maybe 2 minutes, we've got about in the interest of time. So let me start with this question here. That's for you, Freya. It's from Adona. 2 minutes. If you want to get more, 2.5. That's it. Yeah. Otherwise, I think you can go offline, and Adona and you and the others likewise can do that, because I really want to incorporate the public chat questions onto this live, and then of course it can go offline after that, please. I hope that's okay with everyone. So without further ado, Freya, and to the others, Adona's question is, I think you can see in the public chat. Can you see that, Freya? Yeah.
Yes, I see. So do you foresee any convergence in the rules on SOEs, or do you see these rules being addressed separately in the different forums I mentioned? Very briefly, I see more and more divergence, perhaps except with the willingness of tribunals to try to circumvent the whole issue by saying, well, whether the conduct is attributable or not doesn't matter, the state should have prevented it, which in a way is falsifying the question, is circumventing the question. And I think that unless there's a more uniform approach, or a more concerted effort to create a uniform approach, this will just get worse. And I also think it's inappropriate that this kind of lawmaking is actually left to individual WTO panel members, investment arbitral tribunals, and human rights bodies. I think we need these rules, and they should be made by states, not by tribunals. Tribunals are not there to make the law; they're there to apply the law.
Thank you. I like the way you ended it. It was good. Very clear for that one. Yeah. So if Edona wants to come back later, she can. If not, it can be done offline. But thank you for that. Again, now there's a question now for you, Freya, but someone's obviously picking on you. So here you are. Could the provisions in GATS, SPS, and TBT agreements that members shall ensure observance of the provisions of those agreements by non-governmental bodies be used as grounds for attribution under your
no. So the rules on attribution for a SIEL are rules where you say, well, this private entity did something, and because of a number of reasons, this has to be, or this can be attributed to the state. Whereas the WTO rules are what I would call the rules that allow you to circumvent attribution. The rules that allow you to say, well, the member violated the agreements, not because they did something wrong, but because they did not prevent an SOE to do something that is wrong, even though the state didn't do it itself. And for the SOE, there may be no rule in place in that regard at all.
Yeah, and that question was asked in relation to operations of SOEs for purposes of WTO law. Would you still?
Yeah,
okay.
I hope my answer covered that. Everybody who thinks that my answers are too short or too unnuanced, please do feel free to email and berate me in private.
Thank you for that. I think it's wonderful. You've given us a carte blanche, as it were, to approach you. And I think this is really wonderful because it is for the interest of everyone. And we're all here for a common purpose to understand SOEs, and you speakers are the people on SOEs now. So it is so appropriate. Thank you so much. Yeah. And that's my horrible mark for 1 minute left, Mark. Okay. So now we have Peter's question. I'm going to just address it to what extent have RTAs such as the CPTPP agreement addressed the issue of SOEs? So can I just say, who would like to answer that question? And then we just go one person each. Is there a raising of hand? Wei, would you like to answer that? Sorry.
Actually, I can suggest a paper that recently wrote by Professor Zhou Weihuan from UNSW. In his paper, he addressed the limitation of CPTPP as a model to address especially Chinese SOE issues. So I suggest this as a reference to answer this question, actually.
Okay, thank you. I saw Freya, you raised your hand as a good student.
Well, you asked for raised hands, and I didn't see anyone else reacting.
No,
so
good, very good.
Actually,
engaging, good.
The whole bit on RTAs is that I have about 15 pages on that, but because of time limits, I had to skip that. RTAs increasingly address SOEs. They define them, they distinguish them from sovereign wealth funds, they deal with delegated authority, and they impose some obligations with regard to non-discrimination and commercial considerations, as well as non-commercial assistance, which they give, and that could make a huge impact if indirectly through an SOE, for example, a state expresses its confidence in a certain company. That kind of expression of trust could already falsify competition potentially. What these chapters do not do on the whole is they have such extensive exceptions. For example, with procurement is entirely taken out of there. Financial services are taken out of there, and in most of these chapters that I've seen or that I've studied so far, there is nothing that I would call a dispute, a solid enforcement mechanism or a dispute settlement mechanism. So, for example, there's these committees that will be convened to discuss matters where it's not even an interstate kind of arbitration thing, let alone that, for example, an injured private party, which could be anyone really, could be an environmental organization who sees that an SOE is wreaking destruction, and actually it's a state's obligation to protect the environment. It could be an investor who's seriously injured. They can do nothing with these chapters. They cannot rely on these chapters. These chapters cannot bring a case under the treaty, and they can, for example, not under the investment chapter, and they cannot invoke this before domestic courts. So it's good that they start addressing this, but it really needs to be worked out a lot further. And then, for example, the CPTPP does allow, or does already include, a provision saying these are topics for further negotiation. So I think this is a space to watch in future years. But at the moment, there's an attempt, but it doesn't really amount to very much.
Good. Thank you. Simple questions generate profound answers. And certainly it's going to be a lot that is in store. I'd like to just get the view of Mark and Wang. Would you like to add just a minute each to what Freya has said? Your answer, if you have one. If you don't wish to, it's okay.
Do you want an answer to that question or
yes,
the next question?
To that question, if you wish to answer it.
No, I agree with Freya. Like there are more and more rules incorporated within RTAs and free trade agreements, but there's just no enforcement mechanism at the moment. Investment agreements may eventually prove to be that enforcement agreement if those state-owned enterprise rules migrate from FTAs into investment agreements, and they are included in investor-state arbitration. But at the moment, there's no enforcement mechanism, so it relies on the goodwill of states.
Okay, thank you. Wang, 1 minute you can add, if you wish.
Okay, I think I basically agree with Freya in terms of the problems in the CPTPP, and I actually have highlighted some differences between in terms of the provisions between the CAI and the CPTPP. For example, in terms of the definition of SOEs and also the substantive obligations, while they, as I said, the CAI, unlike the CPTPP, perhaps focus more on the commercial activities of the state-owned enterprises, and it has a more expansive coverage, a scope of coverage of state-owned enterprises subject to international obligations. But I mean, the problems like the broad range of exceptions and also some other issues remain to be seen in the future.
Okay.
That's my short response. Thank you.
Thank you very much. Thank you. I appreciate that. I wanted to make that an inclusive question for all panel members. I can see that as a entry point for that. We now move on to Shreji, and it's a question for Mark and Lou. So you can read the questions on the public chat, Mark and Lou. Do you read them? Yes? Okay, so Mark, let me just give you 2 minutes. I'm sorry, I really have to be strict here. 2 minutes. If you want more, I'll give you maybe a little bit more, but 2 minutes. Oh, you're muted, Mark. It's okay.
There's a practical issue and there's a legal issue here. As far as I'm aware, there are no investment arbitration cases challenging an investment screening mechanism. That it's just not happened yet. So on the practical level, the inclusion of a pre-establishment national treatment clause is not necessarily an issue in practical terms, but could be in legal terms. Now, I had a quick look when I saw this question in the chat. So the issue is not necessarily the existence of pre-establishment national treatment clause, which there is in the CAI, but it's the extent of the reservations. So if you go into the reservations for both, and there's a separate one for the EU and China, there are 15 sectors which are exempted from pre-establishment national treatment and exempted from the national treatment clause, and they go from kind of real estate, distribution, education, financial services, tourism, recreation, transport, mining. These are all sectors that state-owned enterprises would be involved in. So it's not necessarily the existence of the pre-establishment national treatment clause, but it's the extent of it and the scope of it, and it's really restricted by the reservations. So that's what I would say to that.
Very good, thank you. And also thank you for doing your search work before answering that, because that obviously helps a lot. Lou, 2 minutes.
Okay. Firstly, thank you very much for the question. Actually, a part of my draft paper and other project is, address the, I think, emergence of, a three-year FDI review mechanism at the EU level, and we've seen that there's, a tightening of FDI controls at both the EU and the EU member states level in recent years. As far as the investment agreement between the EU and China has concerned, there's no provisions, I think, specific provisions addressing the specific issue of FDI screenings, and it's mostly, it likely will be, exempted or carved out from the dispute resolution. For example, we've seen some treaty practice like the Australian treaties and the Canadian treaties. It's actually excluded the FDI screening from the investor-state dispute settlement mechanisms. And in terms of the dispute settlement mechanisms under the CAI, it's actually allow the parties to resort to dispute resolution mechanism contained in the agreement in case of breaching investment liberalization commitment and other obligations. And this should include SOE disciplines, but it's very important to note that there's no investor-state dispute settlement under CAI, and the provisions although they state-to-state dispute settlements and other monitoring mechanism at pre-litigation phase may applicable to the obligations on SOE behaviors. So, and I think for the purpose of my draft paper, I think what matters here is that the two parties, the EU and China, are abiding by the international obligations on SOE disciplines under the agreement on investment, and the dispute resolution mechanism under the current treaty text is available for the state elements to address their concerns over SOE behaviors and resolve disputes through consultation, mediation, or arbitration between the two governments. That's my response to the question. Thank you.
Thank you very much, Lou. Thank you very much. We've got 3 more questions, and I'm really going through this list. Thank you for them, public. I appreciate it. So this is for you, Mark. It's from Fabio. You can see it on the screen. So you've mentioned corporate governance as an element of concern. So are there links between Chinese corporate governance for SOEs and the CCP? Could you please elaborate on that point? Only if you wish to answer.
Yes. Yeah, so there are links in practice and there are links in legislation. So in the most recent issue of the Journal of International Economic Law, there is an article by one of my friends, Ru Ding, about the corporate governance of state-owned enterprises, and it outlines quite clearly in legislation where the state has a role to play in the governance of state-owned enterprises. For example, in major decisions in things like dissolutions or acquisitions, the state has a role in law in China. So the CCP, and it lays out very, very clearly the role of the Chinese Communist Party in the governance of some state-owned enterprises. With Chinese enterprises more broadly, there's an article, I think it's called Beyond Ownership. I think it's called Beyond Ownership, State Capitalism and the Chinese Firm. I can't remember who the authors are, but they talk about the revolving door between the regulators and state-owned enterprises, and that even when some enterprises are kind of prima facie private enterprises, they nevertheless have kind of institutionalized party penetration in that way. So they recommend that we go beyond ownership and look at not necessarily more subjective elements, but things like political connections and things like that. So there are links between the corporate governance of SOEs and the CCP.
Thank you. I put in my Gmail address only because if I encourage, if you want to do that, so that will enable offline conversations. Thank you very much. You have enabled us to approach on a wider context, like the friend who you mentioned who written an article. That's really helpful. And Now, this is a question that is from Bianca, and it's to thank all the panelists for insightful presentations. So that's great. Now, she has a question to Mark and to Freya, and that question is here. The screen keeps going up. Okay. Although investment treaties might be seen as largely available to SOEs, the question is, what do you think about the approaches adopted by investment tribunals when addressing SOEs as claimants in investment arbitration? And she asked there's a specific question as well. It's quite a bit. So I think because
I have a very short answer to this. If you want me to give you a short answer.
Okay, then yeah, go ahead. Sure.
So investment arbitration have taken an approach that looks at not necessarily the purpose of the investment, but kind of analyzes the organization of it. There's a difficulty in not wanting to attribute and exclude state-owned enterprises from the purview of international investment law. The difficulty is that states have not necessarily made that clear in their investment treaties. That is, in my view, an approach that arbitral tribunals are taking themselves. It's not explicit within investment treaties that state-owned enterprises are included. And in fact, in the ICSID Convention, it explicitly provides that only private entities should be included. So, I mean, my recommendation in relation to how investment arbitration have dealt with the definition of SOEs is that states should be explicit in including them or not. So that's my short answer to that.
Okay.
Should I add one sentence, or should we leave it at this? Suresh?
No, you can, please. There was a question to you, so please do answer.
I'll just deal with the last part of the question. I think no, DRC while not necessarily the only way to address SOE standing. First of all, because they were not meant to deal with standing, they were meant to deal with wrongful acts, which standing is not. But I do think we have to be careful that we don't develop a special set of rules aimed at Chinese SOEs. I think we should have a uniform set for SOEs, regardless where they come from. And yes, the European Court of Human Rights more comprehensive approach could be interesting also in the context of investment arbitration. Thank you.
Thank you. I know those questions were asked specifically to Mark and to Freya. Just in the spirit of openness, Wang, do you want to add something? 1 minute.
I think I just agree with Freya in terms of the approach we need to adopt in response to SOEs, because that's not a specific question of China. I mean, there's some common problems that we need to address in future international investment rulemakings and investment arbitration practice. That's my short response.
Okay, thank you. Wei, would you like to add anything to the other three? Please.
Actually, thank you, Suresh. Actually, I'm agree with what Freya just suggested, a uniform approach to regulate SOE, rather than specifically target one country with SOE. So that's why I said we should also consider SOE as a stakeholder to involve in this rulemaking process. But I think maybe WTO still have to play a key role in a more multilateral rules concerning SOE relevant issues, because there is no other multilateral platform to achieve such a wide range of consensus. Yes. Thank you.
All right. Thank you. Thank you for that and sharing with us. I think I've addressed all the questions in the public chat, which has been kind of challenging in the sense I really want to get everyone on board and to have questions being asked. So I reiterate that I've seen the emails being sent out as well, the addresses. So if you want to have offline, please, I encourage that. And I want to end now in the sense of just doing a quick summary. We've gone on a journey. This is wonderful, and I've really enjoyed it. I've really, truly enjoyed it. And I hope likewise my panel members have enjoyed it. It's been great working with them and with the public chat. It's fantastic, when you see the chats coming in and how to sieve them through and all that and have an engaged process. I just want to do a quick run through. To me, takeaways are so important. When I entered this forum, like SOEs, yes, we hear them, but this is so important to me, and I just want to give you my takeaway. And I apologize because it's just my sense, and I want to feel that that we all can share this. The society I mentioned, international economic law, and this is what makes us tick. And here, GATS Article 17, 1947, we went through characteristics of SOEs and the concerns, OECD SOE guidelines, tests, subjective, objective. Then we have the internationalization of Chinese SOEs. We had the global financial crisis, 2008. And then you have the International Law Commission, the state responsibility, human rights, adjudication. And then we ended on this EU Kai done by Lou as well. So there's I think like we walked through like what it is, and then we've been walking the steps, and then now we come to this Kai, and I can sum up in one word or maybe 4 words: uniform set of SOEs. That's the direction. Whether it is, jury's still out, but this is what we can generate the debate to be. We can move on. I think Wang mentioned about WTO playing a key role. We all know key roles need to be played. So I hope I can see that as a takeaway, that we've gone on this journey for SOEs, and the debate is still on. It's topical, very much on the agenda. And on that note, I want to end, but if there's anyone who wants to say anything, just say a word, just quickly, a minute. Wei, floor is yours. You want to say anything just in 1 minute?
Actually,
Yes.
Lou just suggests me my network is not stable. So during the whole session, I'm not clearly appeared in the screen. Actually, I'm with 1 minute's conclusion. Actually, I really enjoyed the discussion with all of our panelists, and they also have some interaction with everyone's statement. Actually, maybe my presentation give a more comprehensive issue and problems in relation to how to regulate SOE, and what might be the right direction, and what might be a suitable way to understand SOE. And Freya also mentioned an important issue concerning the attribution rules that is really fall into my personal interest. And Lou and also Mark addressed the issue of Chinese SOE, and also the emerging rules concerning addressing the issue of SOE, especially from investment treaty perspectives. So actually, I really enjoyed our today's conversation rather than presentation, I think.
Thank you very much. Okay, this is just going to be a checkout, because I just think we're going to check it out as it is. Freya, your time to check out. 1 minute. You're muted.
That I'm happy to do so, but I think many people also might want to go to the networking session, so I'll keep it at this. Thank you.
Okay.
Thank you.
Thank you. Mark, a checkout.
Just to say that an enjoyable panel. Thanks, everyone.
Very profound. Thank you. Lu Wang.
I also want to thank everyone, and from the audience and also from the panel. Great moderator for such amazing discussions, and I really enjoyed it. Thank you.
Thank you. So from us the panel. We wish everyone be safe and looking forward to seeing you again in other panels as well. Thank you very much. Thank you for joining us. Thank you. Thank you all.
Thank you. Bye-bye.